Hello everyone, in this video we will discuss MCQs of Indian Evidence Act. These MCQs will be more than 1000. So let's get started from the question number 1. As per section 1 of Indian Evidence Act came into force on, here correct answer is option B, that is September 1, 1872. Indian Evidence Act came into force on September 1, 1872. Question number 2. As per the preamble of the Indian Evidence Act 1872, the purpose of this act is to consolidate, define and amend the law of evidence. Therefore, option D is the right answer. Question number 3. The Indian Evidence Act 1872 has been divided into dash parts and dash chapters. Here, correct answer is option B, that is 3 parts and 11 chapters. Question number 4. How many sections and chapters are there in Indian Evidence Act? Correct answer is option A, 167 sections and 11 chapters, divided into 3 parts and 11 chapters. Question number 5. The Indian Evidence Act applies to option A, the whole of India excluding the state of Jammu and Kashmir, option B, all judicial proceedings in or before any court, and option C, all proceedings before an arbitrator, option D, affidavits presented in any court or officer. Here correct answer is option B, all judicial proceedings in or before any court. Question number 6. The Indian Evidence Act is applicable to Jammu and Kashmir and Nagaland, Jammu and Kashmir, Nagaland and scheduled tribal areas, all of the above. Correct answer is option D. Question number 7. Under section 1 of the Indian Evidence Act, the proceedings which are specifically excluded from the operation of the Indian Evidence Act. Option A, proceedings before industrial tribunals, proceedings before arbitrators, proceedings before administrative tribunals. D, none of the above. Here correct answer is option B, proceedings before arbitrators. Question number 8. The Indian Evidence Act does not apply to the proceedings before the arbitrator, affidavit submitted by the dependent on his own, option C, statement made by a child, and option 4, statement of a person whose past is criminal. Here correct answer is option C. Option 1 and option 2 are correct. Indian Evidence Act does not apply to proceedings before the arbitrator and affidavit submitted by the deponent of his own. Question number 9. Which of the following statement is correct? The Indian Evidence Act applies to affidavits. The Indian Evidence Act applies to a proceedings whose object is to determine a dual relation between one person to another. Indian Evidence Act applies to arbitration proceedings. The Indian Evidence Act applies to departmental proceedings. Here it has been asked which of the following statement is correct. Option B is correct because Indian Evidence Act applies to proceedings whose object is to determine a dual relation between one person and another. Question number 10. Select the incorrect statement using the codes given below. Statement first, the Indian Evidence Act does not apply to arbitration proceedings. Option second, the Indian Evidence Act does not apply to the proceedings before a commissioner appointed by the Court of Recording Evidence. Option 3, the Indian Evidence Act applies to affidavits presented to courts. And option 4, statement 4, the Indian Evidence Act applies to judicial proceedings held before all kinds of military courts. Here, correct answer is only option 1, that is Indian Evidence Act does not apply to arbitration proceedings. Second, third and fourth statement are not correct. Therefore, correct answer will be option B. 2, 3 and 4 are incorrect. Question number 11. The Indian Evidence Act was drafted by option A, Lord Macaulay, option B, Sir James Stephen, and option C, Huxley, and option D, Sir Henry Summer Mine. Here the correct answer is option B, that is Sir James F. Stephen. Indian Evidence Act was drafted by Sir James F. Stephen. Question number 12. Any such fact which possesses probative fact is called evidence. This definition is belonged to Salmon. Question number 13. The maxim false in omnibus means. Correct answer is option B. If a thing is false in respect of one, it must be taken to be false in respect of all. Question number 14. The maxim falus in uno, falus in omnibus is option A, a sound rule of evidence, option B, a sound rule of law, option C, both A and B, and option D, none of the above. Here correct answer is option B, that is a sound rule of law. Question number 15. Principle of falus in uno, facilis in omnibus is option A, rule of law, option B, rule of caution, option C, not applicable in India, option D, both rule of caution and non-applicable to India. Here correct answer is option D, both rule of caution and not applicable in India. Question number 16. Point out the correct answer. Law of evidence is lex talens, lex fori, lex loci, lex citus. Here correct answer is option B, lex fori. Lex fori means law of forum. Question number 17. The Indian Evidence Act 1872 is not exhaustive. Many rules relating to law of evidence are contained in option A, CPC, option B, TPA, option C, Indian Succession Act, and option D, all of the above. Correct answer is option D, all of the above. Question number 18. To which of the following does the Indian Evidence Act apply? Option A, affidavits. Option B, non-judicial proceedings. Option C, arbitration proceedings. And option D, judicial proceedings. Correct answer is option D, Indian Evidence Act applies to judicial proceedings. Question number 19. The Indian Evidence Act 1872 applies to administrative tribunals proceedings, arbitrators proceedings, contempt proceedings, none of the above. Here correct answer is option D, that is none. Question number 20. Section 2 of the Indian Evidence Act was repealed by. Section 2 was repealed by Repealing Act of 1938. Question number 21. Which word has not been defined under Section 3 of Evidence Act? Option A, confession. Option B, court. C, fact. D, document. Correct answer is option A. Confession is not defined in Indian Evidence Act. Question number 22. The affidavit given to the court is not an evidence, merely a written statement, a proof. Correct option is option B. Affidavit given in the court is an evidence. Question number 23. Indian Evidence Act applies to civil proceedings only, criminal proceedings only, both the civil and criminal proceedings, none of the above. Correct answer is option C, both civil and criminal proceedings. Question number 24. The law of evidence under the Indian Evidence Act 1872 is substantive law, procedural law, substantive and procedural law, none of the above. Correct answer is option B, that is procedural law. Question number 25. The law of evidence consists of which one of the following? Option A, ordinary rules of reasoning. Option B, legal rules of evidence. Option C, rules of logic. And option D, all of the above. Here correct answer is option B, that is legal rules of evidence. Question number 26. Which one of the following term has not been defined by the Indian Evidence Act in section 3? Option A, court. Option B, document. Option C, evidence. And option D, confession. Correct answer is confession. Question number 27. Which one of the following is not defined in section 3 of Indian Evidence Act? Court, document, evidence, confession. Here correct answer is option D. Confession is not defined in section 3 of Indian Evidence Act. Question number 28. Which one of the following is not included in expression court under the Indian Evidence Act? Option A, all judges. Option B, all persons legally authorized to take evidence. Option C, all magistrate. And option D, arbitrators. Arbitrators are not included in expression court under the Indian Evidence Act. Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Therefore, here it is been asked which of the following is not included. Arbitrators are not included will be the right answer. Question number 29. In the Indian Evidence Act, the expression court means all judges, all magistrates, all persons except arbitrators legally authorized to take evidence, all of the above. Here correct answer is option C. All persons except arbitrators legally authorized to take evidence. Question number 30. The term court as defined in the Indian Evidence Act does not include. Option A, presiding officer of a labor court, tehsildar, arbitrator, commissioner appointed by a civil court. Correct answer is option C. Arbitrator is not included in the definition of court. Presiding officer at labor court will be considered, tehsildar will be considered, and also commissioner will be considered. Question number 31. Which one of the following is not included within the definition of the term court under the Indian Evidence Act? All judges, all magistrate, all consumer forums, all persons legally authorized to take evidence. Here correct answer is option C. All consumer forums are not included within the definition of the term of court under the Indian Evidence Act. Question number 32. In relation to the expression defined in section 3 of Indian Evidence Act, which of the following statement is not correct? Option A, facts includes any mental condition of which any person is conscious. Option B, courts includes arbitrator. Option C, an inscription on a mental plate in a document. And option D, a fact is said to be not proved when it is neither proved nor disproved. Here correct answer is option B. Courts includes arbitrators. Question number 33. In relation to the expression defined in section 3 of Indian Evidence Act, which of the following statement is not correct? Option A, facts includes not only physical fact but also psychological facts. Courts includes arbitrator. This statement is not correct, therefore B will be the right answer. Question number 34. Facts can be physical facts, psychological facts, physical as well as psychological facts, and option D, only physical facts and not psychological fact. Here correct answer is option C. Facts can be physical as well as psychological facts. Question number 35. In the law of evidence, fact means and includes option A, anything perceived by the senses. Option B, state of things capable of being perceived by the senses. And option C, mental condition of which a person is conscious. And option D, all of the above. Here correct answer is option D, all of the above. In law of evidence, facts means and includes anything perceived by the senses, state of things capable of being perceived by the senses, and mental conditions of a person of which a person is conscious. Question number 36. A fact under section 3 of Indian Evidence Act means and includes anything capable of being perceived by the senses, state of things capable of being perceived by the senses, relation of things capable of being perceived by the senses. Option D is the correct answer. Question number 37. Under Indian Evidence Act, fact means option A, factum probandum, option B, factum probans, option C both A and B, and option D none of the above. Here correct answer is option C, that is both A and B, factum probandum and factum probans. Question number 38. Which one of the following is a fact? Hari said, Mohan saw, Ram told a lie. All of these. Correct answer is option D, all of these. Question number 39. Which of the following is a fact? That there are certain objects arranged in a certain place. Option B, that a man heard or saw something. Option C, that the man said certain words. And option D, all of these. Here correct answer is option D, all of the above. Question number 40. There are certain objects arranged in a certain order in a certain place is a fact. Question number 41. Which of the following pairs is not correctly matched? That a man heard or said something is a fact. A map or plan document. Copies made from or compared with original evidence. Fact connected to a fact in issue in such a manner as to constitute part of the same transaction. Rule Nisi. This is not correct. This is res geste. So 41 not correctly matched is option D. Question number 42. Facts under the Evidence Act means anything capable of being perceived by the senses only, anything not being capable of perceiving by the senses only. Option C, any mental condition of which any person is conscious, and option D, anything capable of being perceived by the senses and any mental condition of which any person is conscious. Under Evidence Act, facts means anything capable of being perceived by the senses and any mental condition of which any person is conscious. Option D is the correct answer. Question number 43. Whether a weapon is a deadly weapon is a question of option A, law, option B, fact, option C, opinion of the expert witness, option D, opinion of the judge. Correct answer is option B, that is fact. Question number 44. Which of the following is not a fact? Option A, mental condition, option B, relation of things, option C, state of things, and option D, none of the above. Correct answer is option D, none of these. Question number 45. The fact sought to be proved is called factum probandum. Option B is the correct answer. Question number 46. Which of the following qualities to be treated as fact within the meaning assigned to it under the Indian Evidence Act? That a man heard or saw something, that a man holds a certain opinion, that a man acts in good faith, all of these. Here correct answer is option D, all of these. Question number 47. Which one of the following is a fact? Sohan saw a cow, Mohan said Sohan to go, Sheetal has a high reputation, all of these. Here correct answer is option D, all of these. Question number 48. A reputation of a person is a fact, a subject, an opinion, and evidence. A reputation of a person is a fact. Option A is the right answer. Question number 49. A witness described in detail the articles decorated in the room while giving statement before the court. This is a option A, fact, option B, opinion, option C, document, and option D, cause. Here correct answer is option A, fact. Question number 50. Anything, a state of things or relation of things capable of being perceived by the senses is option B, fact. Correct answer is option B.